I am Bill Rochelle, editor-at-large and columnist for American Bankruptcy Institute, and this is Rochelle's Daily Wire Weekend Video Edition, where we recap the most important developments in bankruptcy law in the prior week. We're coming to you today from ABI's satellite offices in the desert Southwest. This week, it's easy to pick what we should talk about. It's a decision from the First Circuit deepening a split of circuits about the rejection of executory contracts involving trademarks. This controversy began back in the mid-1980s with the Fourth Circuit's decision in Lubrizol, where that Court of Appeals held that the rejection of an executory contract licensing intellectual property precluded the licensee from continuing to use patents, trademarks, copyrights, and the like. Congress reacted almost immediately, 3 years later, by modifying two provisions in the Bankruptcy Code which have the effect of allowing a licensee of most intellectual property to continue using such things as patents if the license agreement was rejected as an executory contract. However, Congress very pointedly left out anything saying what happens to trademarks. As a result, there had been a split among the lower courts. Does the rejection of a trademark license agreement preclude the continued use of the trademark? Well, that is exactly what the Fourth Circuit held in a case called Mission Products versus Technology. In a 2-to-1 decision, the majority held that rejection of a trademark license, just like Lubrizol, precludes the licensee from continuing to use the mark. That decision made a stark split of circuits because in 2012, in the Sunbeam case, the Seventh Circuit held the exact opposite, that outside of bankruptcy, the breach of a trademark license by the licensor does not preclude the licensee from using the mark, and the result should be precisely the same in bankruptcy, according to Circuit Judge Frank Easterbrook. Also, by the way, reaching the same result as the Seventh Circuit was a concurring opinion in 2010 by Circuit Judge Tom Ambrose on the Third Circuit. Well, what we have is a very clear split of circuits, and by all rights, this is a decision that the Supreme Court ultimately should make, and I hope sooner rather than later. In any event, we will give you further reports on Rochelle's Daily Wire and on the ABI website. But meanwhile, stay tuned, and we'll be back with you same time next week for the most important event in that week in the life of bankruptcy. Thank you. Good day.